Okay, so I'm just going to continue with this video on this day of February 20, 2026. It is 10:35 a.m. I stated that within the near future I was going to state something in regards to the falsification of my records by the asshole Dominic Coletta. And I might as well just do it now. So what I think is that he got the idea to falsify my records through the filings of Carl E. Calabrese. Attorney was David M. Lynch of 333 Babbitt Road, Suite 333, Newport, Ohio 44123. Carl E. Calabrese appeals from the order of the trial court denying his motion to vacate his guilty plea to intimidation. He assigns the following error for our review. The trial court committed error by denying Calabrese's motion to vacate his plea because Calabrese was mentally incapable of entering his guilty plea on the day that he entered it. Having reviewed the record and pertinent law, we affirm the record reflects that in 2004, the Cuyahoga County Probate Court issued an order finding Calabrese incompetent and appointing a guardian for him. Several months later, Calabrese pled guilty in case number CR 03443466 to intimidation, attempted intimidation, and vandalism, apparently in connection with actions against a Lyndhurst Municipal Court judge. Calabrese was sentenced to 3 years imprisonment. On December 18, 2014, Calabrese was indicted on one count of intimidation arising out of statements that he made to a Mayfield Heights Police Department employee, again concerning the same Lyndhurst Municipal Court judge. In January 2015, after Calabrese's counsel advised the court that the guardianship remained in effect, Calabrese was referred to the court's psychiatric clinic and the matter was transferred to the court's mental health docket. The February 12, 2015 and April 16, 2015 reports of the psychiatric clinic indicated that Calabrese has bipolar and substance dependency issues. He was prescribed mood-stabilizing medication and was determined to be eligible for the court's treatment in lieu of a conviction program. At a hearing on April 23, 2015, the parties stipulated to the court psychiatric reports. Defense counsel also explained that the probate guardianship arose from Calabrese's bipolar disorder and that Calabrese's father is his guardian. Defense counsel stated that as long as Calabrese takes his medications, he seems to be fine and able to cope with everyday life. Calabrese informed the court that he wished to enter a guilty plea and the trial court undertook a criminal Rule 11 plea. Colloquy, I like to pronounce words correctly. C-O-L-L-O-Q-U-Y. Colloquy. Colloquy. In relevant part, the court asked Calabrese whether he understood the proceedings, and he stated that he did. He also denied under the influence of any drugs, alcohol, or medication that would adversely affect his ability to understand what was happening or to enter into a plea. At the conclusion of the colloquy, the court stated, "The court is satisfied that defendant has been informed of his constitutional rights and understands the nature of the charges, the effect of a plea, and the maximum penalties which may be imposed. The court further finds that the defendant's pleas will be made knowingly, intelligently, and voluntarily." After Calabrese pled guilty to intimidation, defense counsel asked the court to place Calabrese in the treatment in lieu of a conviction program. The trial court granted the motion and the case was stayed so that Calabrese could enter treatment in lieu of conviction. He was supervised by the court's mental health unit. He was required to attend his doctor's appointments take prescribed medication, undergo drug testing, attend sobriety meetings, and report to his probation officer on a weekly basis. By June 24, 2015, however, Calabrese had tested positive for marijuana 5 times and positive for cocaine once. The court continued the intervention program, but Calabrese continued to test positive for marijuana. Calabrese also missed required group meetings and was inconsistent with required 12-step meetings. The court found him to be in violation of community control on November 6, 2015. The court also ordered a re-evaluation of Calabrese's medication on the same date. The matter was scheduled for sentencing on December 7, 2015, then was continued until January 26, 2016. 4 days before the sentencing hearing, Calabrese's counsel moved to withdraw the guilty plea, asserting that Calabrese did not have a full understanding of the effect of the plea that he entered, nor did he understand the consequences attached thereto. The court held a hearing on the motion to vacate the guilty plea. Calabrese testified that at the time of his plea, he did not know the meaning of the term in lieu of conviction. Calabrese's guardian, his father, also testified that in the most recent report prepared for the probate court in November of 2014, Calabrese was deemed mentally impaired due to bipolar disorder that affected his concentration and comprehension. The guardian acknowledged that he was present for the guilty plea. The guardian acknowledged that he was present for the guilty plea, however. Thereafter, the court denied the motion to vacate the guilty plea, noting that Calabrese had highly competent counsel and that the competency in probate is completely different from whether you can legally take a plea and be competent to understand the nature of the proceedings against you in a court of law. So a judge and a lawyer are, in fact, able to assess whether someone understands the nature of the proceedings against them, including the judge who conducted the plea proceedings, who had been a mental health court judge for many, many years, who conducted a very thorough colloquy with your client at the time. The court then sentenced Calabrese to 18 months imprisonment. Motion to vacate. Paragraph 10, Section A. Pre-sentence motion to withdraw a guilty plea should be freely and liberally granted. Nevertheless, it must be recognized that a defendant does not have an absolute right to withdraw a plea prior to sentencing. Cite State v. XIE 62, Ohio, ST 3D 521, 527, 584, NE 2D 715, year 1992. We review pre-sentence motions to withdraw guilty pleas for an abuse of discretion. ID. Paragraph 11. In determining whether the trial court abused its discretion by denying a defendant's motion to withdraw a plea, we consider the following factors. 1. Whether the accused was represented by highly competent counsel. 2. Whether the accused was afforded a full hearing pursuant to Criminal Rule 11 before he entered the plea. 3. Whether, after the motion to withdraw was filed, the accused was given a complete and impartial hearing on the motion. And 4. Whether the record reveals that the court gave full and fair consideration to the plea withdrawal request. State v. Peterson, 68, Ohio, APP, Appeal, 2D 211 428, NE 2D 863 within the 8th District, year 1980. I'm sorry, that was the citing for paragraph 11. Paragraph 12. This court has also set forth additional factors to consider, including that, number 1, the motion was made in a reasonable time. Number 2, the motion stated specific reasons for withdrawal. 3, the record shows that the defendant understood the nature of the charges and possible penalties. And 4, the defendant had evidence of a plausible defense. Cite State v. HISA, 8th District, Cuyahoga, 101-8877, year 2015, State of Ohio, 2269. Paragraph 19, State. This is still a citing. This is still a citation. Paragraph 19, State v. Pennell, 8th District, Cuyahoga County, Number 89352, the year 2008, State of Ohio, 956. Also citing paragraph 13. And this is how it's shown. Paragraph 13. In this matter, we find no abuse of discretion. The record demonstrates that Calabrese was represented by highly competent counsel and that prior to entering the plea, Calabrese was referred to the mental health court and referred to the court psychiatric clinic for evaluation. Prior to the plea, the parties stipulated to the court psychiatric clinic reports. These reports indicated that Calabrese has bipolar disorder with psychotic features, but he was prescribed mood stabilizing medication and was eligible for supervision through the mental health court. Paragraph 14. Additionally, Calabrese was afforded a full hearing pursuant to Criminal Rule 11 before he entered the plea. During the Criminal Rule 11 colloquy plea, Calabrese indicated that he understood the proceedings and was not under any medication that would impair his understanding. The court determined that the plea was knowingly, voluntarily, and intelligently made, then transferred Calabrese to the supervision of the mental health docket. Calabrese's trial counsel also stated that as long as Calabrese takes his medications, he seems to be fine and able to cope with everyday life. Therefore, it appears from the record that Calabrese understood the rights he was waiving as well as the nature of the charges and possible penalties. Paragraph 15. Further, the trial court gave Calabrese a complete hearing on his motion to vacate the guilty plea and also gave full and fair consideration to the plea withdrawal request. During the hearing, the court concluded that the motion was not made in a reasonable time because it was filed almost 2 years after the guilty plea. As to this factor, the trial court found things seemed fine, especially as you were continued through probation. It might be that you recognize that your non-compliance might subject you to further punishment, is when all of this came up. Now, certainly I find it to be disingenuous about the standard. Just having a change of heart, in fact, is not enough to overcome your plea. Paragraph 16. Finally, regarding the reasons set forth in the motion, we note that under RC 2945.37F, the court shall not find a defendant incompetent, citing the standard for determining competency to stand trial and the competency to enter a plea are the same. State versus Bolin, 128 Ohio Appeal 3D 5861713, NE 2D 1092 8th District, year 1998, citing Godinez versus Moran, 509 U.S. 389 113, S. Court, I'm assuming Supreme Court, 2680-125 LED 2D 321, year 1993. So now that I read that citing, let me then now, because I broke paragraph 16 in half to read that citing. So now let me go back and read paragraph 16 in its entirety. Finally, regarding the reasons set forth in the motion, we note that under RC 2945.37F, the court shall not find a defendant incompetent, citing. Now I read that citing, now I'm going to continue with the paragraph. To stand trial solely because the defendant is receiving or has received treatment as a voluntary or involuntary mentally ill patient under Chapter 5122 or a voluntary or involuntary resident with an intellectual disability under Chapter 5123 of the Revised Code, or because the defendant is receiving or has received psychotropic drugs or other medication, even if the defendant might become incompetent to stand trial without the drugs or medication. Paragraph 17. As this court noted in State versus Holman, 8th District, Cuyahoga, number 1000468, year 2014, the State of Ohio, 3908, paragraph 9. Incompetency is defined as a defendant's inability to understand the nature and objective of the proceedings or presently assist in his defense. Cite State versus Mangus, 7th District, Columbians, number 07, CO36, year 2008, State of Ohio, 66210. Within, continuing to cite, paragraph 66, incompetency is not equated with mere mental or emotional instability, or even with outright insanity. Cite State versus Were, W-E-R-E, Were, 118, State of Ohio, SD 3D 448, year 2008, State of Ohio 2762 890 NE 2D 263, citing paragraph 47. A defendant may be emotionally disturbed and still be capable of understanding the charges against him and of assisting his counsel. ID Mangus, citing State v. Bach 28, State of Ohio, SD 3D 108 110 28, State of Ohio, B 207 502 NE 2D 1016, year 1986. End of citing. End of citation. Paragraph 18. New citation. Accord State v. Brooks, 9th District, Lorraine, numbers 90CA004960 and 91CA005035, year 1992, State of Ohio, Appeals, Lexis, LEXIS, 357, January 29, 1992, in which the court stated, competency determinations in the criminal court and in the probate court are independent. State EXREL Davey v. Owen, year 1937, 133, State of Ohio. 96. The competency or mental capacity of an individual under indictment must be determined by the Court of Common Pleas pursuant to the provisions of RC 294537 and not by the probate court. ID at 104, RC 2111.13, which outlines the powers and duties of a court-appointed guardian, does not provide for any powers of the guardian in criminal proceedings. The fact that the defendant has a guardian does not ipso facto mean that he is not competent to stand trial. In fact, an individual could be found insane by the probate court, yet he be declared sane by a court for criminal proceedings. Cite Davey Supra 104. Cite, see also State v. Bush, 12th District, Claremont number CA 2015-06046, 2016, Ohio 551. Cite paragraph 10. The fact that a person may be found incompetent under RC 2111.01d does not mean that the person is incompetent to stand trial. The former is not dispositive of the latter. Cite State v. Barnes, 12th District, Butler, number CA 2004-07084 and CA 2004-10126. Year 2005, Ohio 5290. Cite paragraph 48. Even if a person is found to be incompetent for purposes of RC Chapter 2111, that person may still be capable of understanding the nature and objective of the proceedings against him and of assisting in his own defense. End citation. Paragraph 19. A trial court's finding that a defendant is competent to stand trial will not be disturbed when there is some reliable and credible evidence supporting those findings. Cite WER 118, Ohio, ST 3D 448 at paragraph 46. End citation. Paragraph 20. In accordance with all of the foregoing, the trial court did not abuse its discretion in denying Calabrese's motion to vacate his guilty plea. Calabrese was referred to the mental health docket, and the parties stipulated to the court psychiatric reports. The court conducted a thorough criminal Rule 11 colloquy and determined that the plea was voluntarily, intelligently, and knowingly made. His counsel advised the court that so long as Calabrese takes his medication, he seems to be fine and able to cope with everyday life. Parenthetically, the record clearly reflects that Calabrese was deemed competent during the prior case number CR03 443 466, despite the existence of the probate court guardianship. Therefore, despite the probate court's finding of incompetency, the trial court could, within the sound exercise of its discretion, conclude that Calabrese was competent to enter a guilty plea in this matter. Paragraph 21, the assigned error is without merit. Paragraph 22, judgment affirmed. It is ordered that appellee recover of appellant costs here in text. The court finds that were reasonable grounds for this appeal. It is ordered that a special mandate issue out of this court directing the Common Pleas Court to carry this judgment into execution. A certified copy of this entry shall constitute the mandate pursuant to Rule 27 of the Rules of Appellate Procedure. Patricia Ann Blackman, Judge. Kathleen Ann Keough, AJ, and Mary J. Boyle, J. Concur. So this Carl E. Calabrese seems to have issues with marijuana and cocaine. And I'm just curious if this is where Dominic Coletta got his idea to put Carl Calabrese's life on me. Because, bitch, that's not okay. Now, I have requested records from Dominic Coletta twice. I have called and sent emails stating this never happened to me. I have absolutely never occurred. I would never, have never, and correct this within 2 separate requests for records and emails and phone calls. And still, the falsification of records against me, which is libel, slander, defamation, continues.